Welcome to Dolly Talk. How is everybody doing today? Oh, we have another fun day of the Timothy Olson trial. We're going to be getting into his testimony in a bit, what he does testify, and see what we get done. It'd be nice to wrap it up today, but we'll see. Hey, Paul, how are you? Scott. Oh, Tracy, good to see you. Hey, Billy. Trixie, good to see you. All right. Let's see here. Remove my. Okay, and look at him, just ready to go with his hand up like a polite little boy. Oh, what more can you ask for?
Tomorrow morning, it will be everybody report by 8:30. State? Yes. Just a reminder, we'll have to go through Mr. Olson's record before he gets on the stand. That's true. Actually, now that he's decided, let's just do that. Mr. Olson, I already decided how much time you get.
Okay, that's fine.
The decision's been made. You can appeal if you don't like. Let's talk about your prior convictions for purposes of you testifying. State, how many did you count? I'm 13. Let me give you a little bit of background. He's been in and out of custody for basically the entirety since 1994. So while several of them are dated, it's generally because this is a continuing act of conduct, and a lot of them are due to credibility crimes, which I think is also important to consider. I'll go through the Wisconsin cases first. 2022 CM12 from Racine County, possession of drug paraphernalia, sentenced on August 30th, 2022. 14 CM 603, Eau Claire County, disorderly conduct.
Objection, Your Honor. That is not me. That's not.
Okay, that's a third violation. We're going to have you removed. Turn on the Zoom in the back. Okay.
Uh-oh.
Let's go off the record and have Mr. Olson removed. This changes things a little bit.
Yeah. Wow. Poor boy's getting removed. Getting put on the Zoom. Hey, Louise, how are you?
No, I was just trying to alert the court.
Mr. Olson, we're off the record. Don't talk.
He just shushed him. Deputy just shushed him. He just got shushed.
Just talking to my attorney. No, it's not my case. I'll object.
Oh, poor guy.
Mr. Olson, we're off the record. Okay.
Okay, so I guess he's going to be.
Everybody else plan for 15 minutes.
Another 15-minute timeout. Okay. Let's see what happens now.
Yes. Make a phone call.
I'm working more on it.
2 weeks ago,
So we're back now.
both are aware, I think maybe 2 weeks ago, there was that countywide issue with the network where the countywide issued laptops could no longer get Wi-Fi access and all the other stuff. It's a hardware software issue that the county had to fix. Well, apparently all those laptops were collected and sent to be worked on or fixed, but none of those laptops have come back to the court. So we may not even have Zoom workable.
Oh, she's been threatening the guy this entire trial that she's going to remove him and he's going to have to participate over Zoom for the rest of the trial. And now that she had to do it, she's like, oh, yeah, we don't actually have the laptops. Maybe I'll just get him to promise to be a good boy again. Damn technology.
That's why.
And that is the face of a judge who's just been felted.
So that's okay. Bill, you ready?
Yeah.
We're back on the record outside the presence of the jury. Mr.
And I don't think they told him Zoom isn't working yet. She tries to play it off like she's going to give him one more chance.
Olsen now joins us in the courtroom. And it's been about 15 minutes, close to it. Mr. Olson, I'm going to ask you whether you are going to follow the court's rules of decorum. And if you promise that you will and you can, then I will allow you to remain in the courtroom and we will proceed with the trial.
I love that. I'll let you remain in the courtroom. Like you don't have a choice. You can't do Zoom apparently. So what else are you going to do?
So my question to you is, can you and will you follow the court's rules of decorum?
I didn't realize I broke them, Your Honor.
And you did, and I am telling you that you did. So my question to you is, can you and will you follow the court's rules of decorum?
I mean, as I said, I didn't realize I broke them. I'm objecting.
It's a yes or no answer.
I mean, I'm doing the best that I can under the circumstances. So,
If I don't hear a yes, then I will have you removed. But if you're willing to follow the court's rules and you can and you will follow it, then we can proceed. Can you and will you follow the court's rules of decorum?
I guess I'm at your, I can't argue anything with you. It's you're the boss. Yes, ma'am.
Okay. Having heard you indicate yes, you will, and you can follow the court's rules of decorum, we will proceed. State, as to prior convictions.
Yes. I stated 2022 Racine. I was talking about a 2013 case and had Mr. Olson waited to the end to respond like he should have. I would have been drawn to my attention that was
A little snippy there, ma'am. Wow. Well, if he just waited his turn, yeah.
a different birth date for Timothy Olson, so that one I can take off the record.
Is that the 14 CM 603 Eau Claire?
Yes.
Okay.
So that one. Then the next one is 2006 CF 5944, operating a motor vehicle without owner's consent. Sentencing date January 9th, 2009. That was 4 years in prison. 2005 CM 913 from Dane County, resisting and obstructing possession of drug paraphernalia. 2005 April 13th of 2005. Dane County, possession of cocaine, second or subsequent, sentenced on April 13th, again, 2005.
What's the case number?
05 CF 273. 2002 Milwaukee, that was a theft conviction, 02 CF 5331. I don't have a sentencing date on that one. Milwaukee cases, as you know, were converted, so some of the older ones are difficult to find on CCAP. 1997 CF 608, Kenosha County case for escape. Sentencing date October 9th, 1997. He was sentenced to 5 years of probation. 1997 CF 474. Another Kenosha case, September 17th, 1997, sentenced to 3 years of prison. That was a theft, false representation conviction. 1997, CF 975195 in Milwaukee. That was a forgery case. That was a converted case, so it's unknown what the sentencing date was. 1994, CF 267 in Kenosha, a forgery uttering. September 4th, 1997 was that sentencing date. And then the rest is his Illinois record. 1999, CF 3052, a theft, which was a felony 3 conviction. July 6, 2000, he was sentenced to 3 years of imprisonment. 2006, CF 4803, burglary, a felony 2 conviction. January 24th, 2007, sentenced to 5 years of imprisonment. 2012, CF 336, larceny, a felony 3 conviction. October 4th, 2012, 2 years of imprisonment. That's all.
Thanks for your permission.
Is that 11?
I count 12.
I'm sorry, that's correct. The 22 CM 12, Racine.
Yes.
Okay, yes, that would make it 12. All right, now, Mr. Olson, as to your response on these convictions?
Well, so as far as the most recent that was listed in Milwaukee, which is 2006, for the record, that case was brought back into court, and the judge, I had an agreement with the court because the charge was operating without owner's consent, but I agreed with the court not to pursue misconduct in that case because I had permission to use the vehicle, and the alleged victim actually did say that I had permission, so because I should have never even been charged to begin with. And there was some other issues with the district attorney. The district attorney that actually was fired because of me, that was on the representation, Kenny Richard Wells. He was fired from the DA's office specifically because something he did in my case. And then he became my defense attorney, and I didn't know that had all transpired. So
he became your defense attorney after you got him fired? My God, sir. What a rough life you've had.
said that I was not guilty of a crime, and misconduct from the district attorney that was defending me. Their case was changed from 5 years consecutive back down to 3 months, and it was released immediately when the judge seen that case. And I thought the case was what is that called? Sealed? I thought it was sealed after that, but
So there was a conviction.
there was a conviction, but it was changed from 5 years consecutive to 3 months on the grounds that I wouldn't pursue misconduct and sue.
Okay, well, what about the other ones? The other cases?
So I guess I would object to all of them necessarily being
I'm sure you would.
relevant. What do you have to say? Yeah, some are definitely way over 20 years old, maybe 30 years old. There's only one that's within the last 10 years, and I believe that's a misdemeanor. I don't even know if that listed misdemeanor.
State, if the cutoff was 10, give me the cases. So anything older than 10 years, don't give me those cases, but just cases within the last 10 years. And let's just be clear, within the last 10 years of 2022.
It would be the larceny.
What's the case number?
That's the Illinois case, 12 CF 336. And the 22 CM 12 from Racine.
For possession. And that gap in time is explained by Mr. Olson serving time?
Correct. For example, in 2006, he served 5 years of imprisonment in Illinois, which would bring you then to 2011. And then he immediately committed the larceny where that was 2 years of imprisonment. And then there is some gap after that, before 2020 and then to 2022.
Mrs. Yang, I have a question.
Yes, Mr. Olson.
So no, I was sentenced to 5 years, but in Illinois that doesn't. So you're actually eligible. That gets cut in half immediately, and then you get 6 months more good time. So it's 2 years, and then I earn another 6 months of good time. I actually only served a little bit over a year, and then I was brought back here to face that ridiculous theft of a vehicle charge. And so I was only from, and I think I was released, I don't know, 2000. I started a little over a year in Illinois, and then I sat here for a year. And so it was not very long. It wasn't.
I'm ready to make my decision. There are various factors for the court to consider in balancing consideration of all of this information as to ultimately what number of convictions may be used for attacking a character for truthfulness. These factors include the lapse of time between the convictions, rehabilitation of the person convicted, the gravity of the crime, and involvement of dishonesty or false statements in the crime, as well as the frequency of convictions. And I think the factors that probably stick out the most here are going to be the frequency of the convictions, as well as the lapse of time, which is explained by the state in that during the times when there were no convictions, that was the time when Mr. Olson was serving time in custody. Given the state's explanation of these convictions, and as outlined by the state, the court is persuaded that the appropriate number of prior convictions for attacking character of truthfulness is 12. So that's what we're going to go with. Now, Mr. Olson, if asked if you have ever been convicted, the answer is yes. How many times? The answer is 12. You stray from that and say something else, that would open the door. You understand that?
Okay. May I comment?
Do you understand that?
Yes.
Okay.
Yes.
Yes. What is it?
So from 2012 to when I was arrested in 2022, there was no arrests, and there was 10 years there that there were nothing happening between that time. There was.
Okay, and I'll explain the 10-year that I asked the state about. There's no fast rule that it must be 10 years, but usually that's my starting point. And when the state explained, which I inquired about those gaps between convictions, it wasn't because you were out there and being a productive, law-abiding citizen. It was because you were in custody doing time. And so while 10-year is usually where I start, it's not a mandatory consideration. Okay, that goes towards the lapse of time between convictions, and that's just where I start. 10 years. It doesn't mean that I'm bound by 10 years. Okay, so now that I've made my decision, we have to really move on. It's 403. Lastly, this is how we're going to proceed. Because of the loss in time and the fact that this is Friday, it's Friday and it's 403, we're going to go to 5:30. When the jury is brought in, I'm going to indicate so and inform them that we're going to go to 5:30 today, because during voir dire and during before I did my preliminary instructions, I believe I also instructed them that the courthouse operation hours. So they're operating on the belief that the court must be closed at 5. I will tell them that we're going to go to 5:30. Additionally, tomorrow morning, we are going to continue the trial if we don't finish. We will be in G55, G55. The deputies will bring you there, Mr. Olson. And my order will be that everyone report by 8:30. It is Saturday.
Oh, look, the deputies are his own personal chauffeur. They'll take him there directly. What super service?
Although I would like everyone to be there at 8 o'clock, I think it's probably not going to be well received by the jurors. So I will reluctantly order that they report to the jury room for G55 by 8:30, which means hopefully by 8:15 they should be making their way through the courthouse security. I will bring the jury in and inform them about the 5:30. I will also inform them about tomorrow. That may have an impact on jurors who are available or not available, and we'll see what they say. As soon as I survey and see who's available, who's not going to be available, and if there's good cause to, I don't know, lose a juror, hopefully no more than 2, then we'll go into Mr. Olson's testimony. And Mr. Olson, I've already reviewed the rules with you, so you know how to testify. Any questions on what I just stated relative to logistics from state? And are you available to go to 5:30 and to report tomorrow to start at 8:30?
Yes.
Okay. And then Mr. Olson, you'll be in custody, and then the deputies will bring you. But Attorney Wasilewski, as for you, 5:30 today and tomorrow at 8:30.
I can make that work, Your Honor.
Okay. Now, I've been told that we cannot go beyond noon tomorrow, so the only time we have is 8:30 to noon tomorrow, and we'll be in G55.
Okay. Really quick, Your Honor. Am I still another 15 minutes to prepare with Attorney Wasilewski for the testimony? I need help.
That is true. I had hoped that maybe you would have already started on that, but that's fine. 4:06 right now, so 15 minutes. Timer starts right now. And then in 15 minutes, let's bring in the jury. Okay, we're off the record.
Wait, Judge loves those 15 minutes.
Yeah, I'm not gonna let them rush me.
Judge opposite team.
Okay, so I'm like out of it. I have a coffee with, so I can drink my own. It's clear bag of coffee with 5 cups, right? And I just mix it into that and drink it.
Oh, he's talking about coffee with this damn guy.
No, I have food back there. I'm just saying coffee. That's different.
I love the hot mics in here. Our trial is hot mic.
Okay, so what? Man, listen, I am not, but it's going to be hard to do this, I'm telling you. I haven't had it.
I gave you a minute or two extra, Mr. Olson.
Class act.
Okay, we are back on the record outside the presence of the jury.
This happened a week ago.
Mr. Olson, there is one thing that one other warning I do want to give you that I didn't give you before, which is that during the course of your testimony, if I give you more than one warning for failing to follow the court's rules relative to your testimony, you will forfeit your right to testify. I will then end your testimony, and then the trial will proceed. Do you understand?
Okay, so if he disobeys her orders, she'll end his testimony. All right, Freddie foreshadowing there.
Understand that?
No, I object to that completely. You're violating every code of conduct you can think of.
Okay, you can object, and that's fine. But I'm letting you know you get one warning. After that, if I have to warn you again, that means that your testimony will be ending and has to end, and then we'll just simply proceed from there. Okay, so no, Mr. Olson, that's it. So what we're going to do next is also relative to logistics. You're going to testify from defense table. It's just going to be easier for you to testify there than to move you to the witness stand. Once you're done testifying, remove the jury and then bring you back. And the logistics is a little complicated. We're going late into the day, so you can just testify from that table. You will be sworn in before you start your testimony. I will let you know. Well, actually, I'll let the jury know that you'll be testifying in the narrative form, and then I'll turn to you for you to then commence your testimony. Okay. Yes, Mr. Olson. So
I need to know exactly what you're saying I can't say or do during this course, or you're going to take away my right to testify. You've already violated enough of my rights. I need to know exactly what you're talking about.
Sure. As I stated, and I've gone over with you before, you are to keep your testimony relevant. That means you cannot talk about the many.
I'm not 100% sure on the black eye, but I know the judge did mention, or someone mentioned, that he was bashing his head against the wall in his cell and gave himself a concussion to try to delay the trial more. So I believe the black eye is probably related to that. Or he just really pissed off someone.
Grievances you have against the court, whether it's me or another judge, you cannot talk about your grievances against the attorneys, whether it's the state or prior defense counsel or current standby counsel. Those things are not relevant. You are to keep your testimony relevant to the allegations made against you relative to any time period. Okay, so we're not talking about when you were born. We're talking about the relevant time period as well. And so those are the rules. Also, part of the rule is that if there is an objection, whether you object or whether it's a state, you must stop talking and then allow the court to rule before you continue your testimony. If I remember, and I'll try to remember, I will tell you that you can continue your testimony. Okay, and that should be the cue for you then to continue. And again, if I have to give you more than one warning, you will forfeit your right to testify and we'll end your testimony there. Any questions on those rules?
Well, I object to think that's really fair, that one warning and you're going to remove my entire right to testify. I'm going to do my best to keep on track. I don't think I would need to speak about anything.
Well, and that's all you can do is do your best. That's all you can do is do your best. But what's important is that you have notice of these rules and that you can follow these rules.
Well,
that's all. We're done with the record. We're going to bring in the jury now. Yes, Attorney Wasilewski?
I have two things. First of all, you instructed Mr. Olson to stick to the time frame of the alleged offenses. One thing we discussed is the possibility of discussing before the offenses in connection with to what extent he may or may not have known Ms. Hannell. And so
I think but that still ties in with the allegation. So when I say the relevant time period, if those alleged acts or knowledge related to whatever may have occurred before the alleged dates of incident is relevant, then fine. It's first and foremost relevant, right? And then secondly, it's not a blanket instruction order from the court that he cannot testify about anything other than the dates of incidents. If there are other things that are relevant that don't fall on those specific dates of incident, fine. I think the guiding post here is whether it's relevant or not.
Okay, second question. If I'm to be seated right next to Mr. Olson while he's testifying, I think we both should know whether the court is allowing or prohibiting us to talk in the course of that testimony, because normally when you're in a witness stand, that simply isn't possible.
Okay, I thought that's a really good point, and I thought I was trying to be efficient, but I think perhaps maybe given that to minimize any chance of that happening, just simply put Mr. Olson in the witness stand.
Your Honor, I would object to that. This would be much easier here, and I will refrain from asking him any questions. You are right; it would be easier from here. I think that given the way that this testimony is going to be given, the only reason I would ask him a question is if it is to be mindful of going outside of your conduct you expect. So that's the only reason I would turn to him, to make sure that wouldn't upset the court. And I think that's a good thing to be here, and to make sure that I would ask him to stay inside that relevant area and without violating any.
Attorney Watson, anything else?
I have nothing else.
Okay, and then State?
Your Honor, that was my concern too, was the proximity. I have to advise my witnesses what to say and not say, and then hope for the best when they're on the stand. I don't get to sit there and have them check to see if that's okay. And two, the credibility instruction itself allows for the jury to see the face of the defendant. And as I get an opportunity to cross-examine Mr. Olson, he's turning around right now to look at me. Sure. And so then I think that is just a very awkward situation as well.
Sure. Convenience and convenience is not going to trump, I think, you're right, as well as you're right to cross-examine effectively, and also to ensure that there is no blurring of the lines between Mr. Olson representing himself and standby counsel, and also, as Mr. Olson pointed out, so that he can follow the rules. And I certainly don't want to put him in a situation whereby, contrary to what he believes, he might actually be more prone to violating the rules than not, because he's seated at the defense table. So for all those reasons, let's have Deputy Bruce, courts change its mind. Let's have Mr. Olson put in the witness stand now to get ready, and then we'll bring in the jury. Again, when we bring the jury, the first thing I'm going to do is survey the jurors. And so, Mr. Olson, while you may be seated at the witness stand, just wait for my cue that you can testify. Okay, let's go off the record while we get Mr. Olson situated, and then bring in the jury.
May I take my notes up there?
Well, you're to testify from memory. If you plan on using exhibits, that's different, but you should not be testifying from
I can
notes.
use exhibits during my.
Of course.
I was not aware of that.
Let's have the pile of exhibits ready for Mr. Olson's use.
Oh boy, he just learned a little new. Oh, he is.
The exhibits are ready and available for your use during the course of your testimony. Okay, so we'll get him. Let's go off the record. We'll just get him situated, and then I'll bring in the jurors. Where can we put it so that it's convenient for him to use?
There's not as well.
There's no sentencing date. Yes, 24 CF 4938. Is that from me or is that from Judge Davila?
I'll just call it down answer.
24 CF 4938. Yeah.
It comes up with that.
Okay, the exhibits are still there? It could be there for him. He can use it.
Okay.
Okay, we're back on the record outside the presence of the jury. Mr.
Witness chair, he's handcuffed, going from the cell to court, and then he's like chained by his feet and then unshackled.
Olson is now situated in the witness box, and we're all set to go. We can bring in the jury. Your Honor, just real quick, I assume it's okay to interrupt if I need to object as we're testifying in form. Follow the same rules and procedure as usual for objection. Just a reminder for the parties to allow the court an opportunity to rule before speaking. Really?
She had to take her brother grocery shopping, and she wanted me to be.
You go back a little bit.
A little harder to recollect everything. So I met Betty maybe within 2 years before 2022, sometime around then. I was doing Uber and I stopped at a restaurant bar. It might have been on 76th Street, somewhere in Greenfield. I think that's Greenfield. Somewhere in that area near Southridge, somewhere out there. And it was I was having a drink and Betty was there and we just spoke friendly. She had frequented this place, she told me, because it was a buy one, get one burger and she liked to go there.
79 burgers.
Outgoing. She was very nice. We just talked. She told me a lot about herself. Her husband passed away, and then she took care of her brother. I forget what she said. He actually lived. I think he lived in someone over there who could take care of him. And then she had mentioned that her sister had passed away, and that she was actually younger than her. And that, she also mentioned that her sister had embezzled all of her brother's money from an account.
What?
And I'm pretty sure it was the brother that she took the money from. It might have been another family member, but I'm pretty sure it was the brother. So excuse me if I'm wrong there. But anyway, I know that Betty had said that she didn't talk to the sister, that she had already passed away after that all happened. She said she always told me that her husband passed away sometime before that, and that they always had gone to Casa de Giorgio.
Giorgio.
And we talked about Rex, and this was even before I went there. I don't remember what else we talked about when we first met. We sort of kept in contact, but not really. And I really texted her. It was not like, there was no, like, it wasn't anything sexual or anything like that. It was she was just a friend. She was nice. We just talked. And I went to her a couple of times in that area because I was always doing Uber. I probably worked 12 to 16 hours a day, 6 or 7 days a week. So I went into a year. I went into her maybe within a week of that date in 2022, and we had planned. She told me to meet her there on Wednesday, I believe, and she had to take her brother grocery shopping, and she wanted me to meet her there. And I said, "Oh, that sounds good." I had been wanting to go there anyway. I actually tried to go into this restaurant numerous times before, but they were closed on the times they said they were open for some reason. I don't think they got a lot of business. But so we were planning there, and she just said she'd get there as soon as she could. That day, I think they didn't open until late afternoon. She had also told me she didn't want Rex to know that we knew each other because she felt odd because she went there with her husband a lot. She just didn't want to have to explain anything, I think. And I understood that. That wasn't a big deal. So when I arrived at first at Casa de Giorgio, I walked in and I sat down at a table at first because Lex was by himself and I didn't know where he wanted me to sit. I would probably sit at the bar right away, but I didn't want to inconvenience him. So I was on the table and I had a drink and I was going to order. And before Betty even arrived, I went and sat at the bar. I asked him if they were right if I sat at the bar when I was watching the sports. And there was actually another gentleman there also. It wasn't just me. And before Betty arrived, he was sitting, I think, 4 or 5 seats down from me at the bar. So I had maybe 1 or 2 drinks I was going to order. I talked to Rex an awful lot. He was really nice, and we got along quite well. he told me about his business, and
Hey, Jim.
I was curious.
What?
In his kitchen, I used to manage restaurants, and we talked about a lot of the food items that he served, and I think I had an appetizer, and that was really good. I think it was calamari, and he had made it a little different. He like sauteed it in some sauce. Let me think. So I don't know how much time went by. It was a considerable amount of time before Betty even arrived there. So I talked to Rex and the other gentleman that was there for quite some time. Again, like I said, when before arriving there, Betty had explained to me that she didn't want Rex to know that we knew each other.
Oh, yeah. Your secret court love affair with a
There's a
79.
little bit more involved in why, the reasons why she didn't want him to know. But for testifying purposes, I'm not going to get into that information. We consider that because this is very important. So, trying to remember anything else that she had told me. Well, she told me that her husband and her frequented there. And she would show me like the booth that they always sat in. She talked about Rex a lot. So when she did arrive, she sat like one stool over from me. We just started talking right away. We just talked about, all sorts of things. Her son, I think it was a laptop that she had just gotten, a new laptop or something. She had her
Kind of
with her as well. I know she had talked about getting a new laptop.
The Dell?
And that she wasn't able to work it properly.
Oh, no. What version of Windows?
I think what else? Rex came over several times and we were all talking together about the menu items, drinks, and I commented he made drinks really well. He was very polite, really kind.
Literally, yes, Billy.
I think Betty ordered wine. I don't remember if she got anything to eat or not. But we talked for quite a while there. It was at least an hour. And I was probably there maybe an hour and a half before she even arrived. So I don't know what time it was at that point. But she was very uncomfortable when we were talking in front of Rex. So to me, I started to get the feeling that she was sort of attracted to me anyway. She had made comments, but she didn't make any. Without.
Yeah, the 79-year-old had the hots for you. Yeah, she was attracted to your masculine physique.
More than that, but I guess I got that feeling because she kept making it clear too that she didn't want Rex to know I was there. I knew her. But like I said, there was other reasons for that. So we decided to leave maybe about an hour after I arrived, and again, she didn't want anybody to know that we had planned to meet there and we were together. But we weren't together like that, like a date. It wasn't a date. It was just friends meeting. And I know she didn't really have a lot of people she talked to. She talked to her brother, who she took care of, and that was really it. But at that time, I was also in a situation where I needed to talk to somebody, and she was nice, so she didn't mind.
Ms. Olson, you have to keep going.
I am.
Keep it along.
So I'm trying to get everything out. It's not easy. It's 4 years ago.
You've testified a lot about the relationship. Okay, now move on.
So we decided to leave, and we walked out together.
Oh, thank you.
But I'm sorry, let me recollect. Okay, no, I wasn't sure exactly what she wanted to do. We didn't discuss if we were going to stay there. She did want to leave because of Rex and go somewhere else, but I wasn't sure what she wanted to do, where we were going. So we did decide to leave, but I wasn't sure what was going on, where we were going, what was going to happen next. And we never like actually ventured out together. It was always just running into each other or briefly speaking. So when we got outside, I went around by her passenger door because it swung open like all the way, and she couldn't reach it.
I wonder if he's going to ever get to the point. This guy's hair freaks me out. Like, I mean, I guess he still has a full head of hair, technically. I mean, you can't take that away from him. But Erica, thank you so much for gifting 10 Dolly Talk memberships. That is very much appreciated. Why did Sal ruin the audio? And yeah, can everyone please like the stream? Thanks, Erica. You are the best. I tried to get the audio all like synced right, but I guess this part it kind of messed up a little bit. If when they go to the other court, for the rest of his testimony, if it's still messed up, I'll try the original feed and see. Okay. Thank you guys so much.
So I went and shut it for her, and then I went around the other side and got in the vehicle. That's no surprise. And I didn't even completely shut the door because I was going to go back in and pay. And actually, I was in some trouble at the time, I guess, and Betty gave me actually like $200.
Objection relevant.
What?
What?
Quick response to that.
Well, as far as like objecting to what she's saying,
Yeah.
I object. It's very relevant as far as what really happened.
Objection overruled. You may continue.
Thank you, Your Honor. So she would bring me, I don't remember how much it was. I didn't count it. I honestly didn't even like accepting it from her. But it was.
Dude, that guy looks like one of the Muppets, the old men in the Muppets. Who's in the balcony?
Odd time, and she gave me the money, and she had given me a Thanksgiving card that she had bought me. And at the time, also, she gave me a birthday card, even though it was well past my birthday, and said that she hadn't seen me, but she had bought the card for me. And I was very appreciative. I think there was a Starbucks card in there that she had bought me, if I remember correctly. One of the cards.
Yeah, it's one of these guys.
It was like a music card where you open it up and it played music, something like that. It was a little bigger, a little heavier. I think it was a birthday card. So anyway, I was about to go back in and pay. She's like, no, it's just saying you can come back later. She wanted me to see me get back out of her car, go back in. She said, just go. I said, are you sure? So I didn't want to do that to Lex because it was really nice, and I wanted to go back right away and pay. And
Break Lex's heart.
she wasn't wanting me to go back in, so I shut the door and we pulled out. She's kind of an erratic driver. She reversed, like really far back into the parking lot, like all the way back behind the restaurant. And
He drives like an old woman.
then finally was able to, because where she was parked at the restaurant, she was right in front of the driver exit. She could just see really well, but she reversed all the way back, I thought that was kind of funny because she didn't want anybody to see us leaving together, and yet she reversed all the way back and then went forward again in front of everyone. I thought they had seen us, but I guess not. So there was another gentleman that was there. I think he was exiting the building when we were pulling out. So from there we were pulling out. I'm thinking we went, what direction did we go? So we weren't really sure where we were going. We pulled out and she turned left into the parking lot of a strip mall right there. It's we were just looking for somewhere to go, and I think that's where like Home Depot is or something. And there's a bunch of like restaurants in that area, bars.
It was an Ace Hardware.
I'm trying to remember where we went from there.
Take your time.
So I think she pulled out of that parking lot and turned onto South 27th Street.
Was it right?
So where?
That was north. No, it was the south.
Oh yeah. Okay. So she pulled back out of the parking lot, and we were facing south on South 27th, and she turned right and went back up. I think that's Rawson. I don't know the name of that road right there where Custody of George goes. I think it's Rawson. And we headed towards 76th Street, I believe. And we were headed towards her house. And because she decided she'd just rather just go maybe have a drink in her house. She wanted to show me her house. And as we got closer, she decided not to go to her house because her neighbors were out. And I don't remember exactly where it was, but I think she must have been really close with her neighbors.
A trip to Duncan.
So from there, I asked if we could, drive somewhere to a liquor store. I was going to grab something to drink for myself because she really didn't know where she wanted to go.
We all need a drink, right?
She didn't like going to many places. And then we drove around for a little bit, and I'm not sure exactly how we ended up. We just were driving, talking, and we were pretty far away from there. And we went back towards like 27th Street and ended up on somewhere on the south side. And it was just like a little liquor store, I don't know, deli looking type place. I don't know the name of it. But we were just driving around, just talking. She was fine with that. She didn't like to go too many places. As far as I know, the only places she went was the one that I originally met her at. I don't know the name of that. And then Custody of Georgia, she didn't really venture out too many places. So I stopped we pulled up at the liquor store. It wasn't really a liquor store, because it was just a store, like a local neighborhood store. And we were putting people outside. She pulled up on the side of the building.
Liquor there.
Pretty far away from the door. And there was people walking around. I got on the passenger seat. And actually she thought I was just going to leave for some reason. She had constantly mentioned, you're going to just leave, are you? I said, no, why would I leave? I don't know, I think she was worried about because she had given me money that I was just interested in the money she gave me, and then I was going to leave, and it was very odd. So anyways, I went in the store and I got
I'm going to skip forward a few minutes.
a few things. I don't know.
This is
I eventually stopped at another gas station. I don't know how long that was.
Your Honor, I'm going to object to relevance again.
Well,
Sustain. Don't talk about that, but continue on.
I object, Your Honor. This is relevant because I went into to a store and left and parked up the road and went back in.
I sustain the objection. Continue though with your testimony.
All right. So after leaving this store that I was in, I walked back up the block. It was busy, so I had to walk about half a block to where I parked. It was a really busy area and busy store for some reason. So I had to walk about half a block back to the car. And I left. And so I don't remember where we went exactly after that. It's been with me, it was quite a long time ago. So we were looking for a place for, she wanted to stop to use the bathroom. We tried, so in that area, a lot of the gas stations don't have bathrooms, or they're not open, or they're locked, because of whatever reasons. Sometimes they just shut them and say, because they don't want problems, some of them are broken, and she couldn't wait anywhere, so she actually just put up in an alley so she could pee, and I really didn't want to, because it was a really bad area where it was, but
Yeah, you didn't want to have this 9-year-old woman.
I just wasn't comfortable with that. So she insisted because she said she couldn't wait. So I put up in the alley and she got out and peed, but I kind of like stood by and guarded, like, I don't know, I didn't really get out of the car. I kind of sitting and just made sure that nobody was going near her or anything. I just had to make sure that she was okay. So she went pretty quickly and got back in the car. I had no idea that I think she said she used her sock. I did not know that. She did that. I would have found somewhere for her to go to the bathroom so she could have used it properly, but she couldn't really understand. Sometimes women are like that. They can't wait. And I guess that's why I kind of understood that. And anyway, we pulled off. That was no big deal at the time. It was a little odd, but she had to go. So anyway, we pulled away from there. I believe we went to. I think we stopped at a restaurant.
Your Honor, we've been talking about going around in circles for now 45 minutes. I object to relevance.
We went together.
The objection under advisement, so I'm going to allow you to continue your testimony, Mr. Olson, but remember to keep it relevant. Okay, continue.
Well, so let me continue with where we went. Is that fine? Okay. All right. So I believe we went to Chili's after this, and that's also right near. Maybe it was Applebee's. That's right. No, it was Applebee's. It's off of. I think it's off of College. I think like 13th or something, somewhere over there. Is there, I think there's a theater over there or a hotel or something. Anyway, we went in there very briefly, but they were closing. And I don't know, I think I had one drink. I don't think she had anything. She was wanting to get something to eat. She didn't eat in Casa de Giorgio. I had like an appetizer, I think. So I was hungry as well, but they were closing, so we went in briefly and then we left. From there, I don't remember where we went. I'm trying to remember what happened after that.
Take your time.
So I think we drove up Rawson again towards 76th Street or Highway 100, one of those roads. And we turned and I got gas at I don't remember what kind of gas station it was. But it was all on camera there. I think I got out, I know, pumped, and there's a lot of people and police cars everywhere. fully aware.
Okay, Mr. Olson, some of those details are not relevant. Okay, so stick to what's relevant. Continue your testimony, please.
Your face isn't relevant.
So I got gas, I filled it up, and I believe I used her card. She let me use the card, or I used the cash sometimes that she gave me when I went into numerous of these places. When I filled up her tank for her, I used her card at this gas station. I believe after this, she asked if.
Objection, this is hearsay, Your Honor.
Sustain.
Oh my God. Well, that can be hearsay then.
And avoid commentaries, Mr. Olson.
It looks like Joe from Impractical Jokers.
Some of the places where they didn't. Was this exhibit
Exhibit
part?
90?
Yes,
Map of Milwaukee area and chronological travel points.
for Betty Annals.
Exhibit 90.
Okay.
Women, am I right?
So from that gas station, we drove.
Your Honor, I'm going to object under 90403 and ask to move on. Even if this is relevant evidence, it's been a confusion to the jury or a waste of time.
What?
Overruled. Continue.
So from there, we went to a hotel on Rawson and Highway 100. I don't remember the name of it. There's like a bar restaurant right across the street. So she asked if I minded if
Objection, hearsay.
Sustained.
she gave me her card to go in to rent a hotel room. And when we got there, she changed her mind. It was, so there was more going on. So we decided not to go there, and we left. I pulled off. I'm not trying to confuse anybody. It's just hard to remember.
No, clearly you're trying to confuse everyone. Thank you so much, Erica, for gifting 10 more. Wow. You're just turning the chat green here. That was very generous of you. Thank you. Gosh, you'll make me blush. Did this guy get punched in prison or kill someone in prison? No, he abducted a 79-year-old woman and drove around with her for several hours.
No
Everything.
commentaries.
All right. Okay.
Are you done, Mr. Olson?
No, I'm trying to remember exactly what happened after that.
Commentary.
Yep. No commentaries.
So after this, I believe we drove to. I'm trying to remember this. I believe we drove to the east side. I don't remember what time it was. I think we were on North Avenue. I remember turning around.
Objection, relevant.
Overruled. Continue.
So we were on North Avenue in front of Jalisco's, I believe it is. And I turned around in a parking lot right there. I think it's a hospital parking lot. And we proceeded to go west on North Avenue. And I think we parked, we were going to go in somewhere on the east side. I don't recall exactly where. I think I turned around Oakland Avenue. And then we parked, and I think we went to a bar or tavern over there. It's around the corner. I don't know the name. It's down another street, maybe right near there. We went there briefly and had a drink. And then we left, I believe, I don't know, maybe it was around midnight at this time. I'm not positive. I don't remember what time we left Casa Giorgio, but I don't think it was 3 o'clock as others stated, but it could have been, but it didn't seem like that because I don't think we drove around that long. But from there we went to, I can't remember the name of the area.
Okay. Mr. Olson, you need to stop making commentaries. If you have statements you're going to make as part of your testimony, make those statements, but do not make comments.
Okay.
We do not need to hear your thought process.
Would you like to know what I had for lunch?
So we go from there to another area, south of the east side.
Your objection relevant. Driving around isn't part of any of the crimes.
Sustained. Okay, continue.
There were no crimes committed. I don't know what crimes were committed there.
Objection commentary.
Mr. Olson, you were instructed by the court to not make any commentaries, and that would have been argumentative with state simply based on their objection. You did not allow the court to rule on that objection in a timely fashion and also in an orderly fashion. Continue, but that's notice to you that you need to testify consistent with the rules the court has set.
Come on.
Am I allowed to speak about where we went from there?
You can testify to what's relevant
It's all,
and follow the court's rules.
okay. I mean, to me, it's
There's no commentary, and the court has made its decision.
So we went to another establishment on I can't remember the name of the area. It's south of downtown, not too far from there. It's a nice area. We went into another bar. It was a very busy area. And we went in somewhere over there briefly. I paid with cash. I don't know how long we stayed. We didn't stay very long. I think it was getting to the point of almost like most of the bars were closing. And
Objection relevance.
Okay, sustained.
okay.
All right, it's 5:28, so I'm going to stop it here, members of the jury. I remind everyone that this case is not concluded. Therefore, you may not talk about this case. You may not talk about your experience. I know that it is tempting when you go home tonight to talk to others, to share your experience, to share what you've heard, but you may not do so. It is improper for others who have not heard this case and do not sit there in the jury box with you to influence your view of the evidence and your judgment. If you just operate on leave. Okay, just one thing I want to know on the record is that juror number 1 did have her eyes closed throughout the testimony. I don't know what that
Us too, juror 1. Us too.
means. Certainly she was still paying attention, I could tell, but she did have her eyes closed. That's noted. Okay, we're beyond the time that I'm allowed to go beyond. So, Mr. Olson, tomorrow morning we're going to continue with your testimony. And given how you did today, I'm telling you that if we're going to give you one warning, and tomorrow, if you fail to follow the court's rules relative to your testimony, I'm just simply going to end it. All right, you've incurred one infraction today already. Tomorrow, if you do it again, you're just done with your testimony. We'll see how you do tomorrow. Even if you don't incur another infraction or violation, I think given the length of your testimony, it might be appropriate for the court to provide a little more guidance or direction during your testimony so that you're not all over the place and that you're not interjecting so many commentaries into your testimony. As I explained, we don't need to know your thought process, okay? And the commentaries that you've made are not relevant and they're not appropriate.
He's making a record.
Okay, that's the court's no, that's the court's order relative to what you can and cannot do.
Okay.
You didn't understand it before, and then I'm putting you on notice that a single infraction tomorrow will result in your forfeiture to continue to testify. We're way over the time I'm allowed, so thank you, everyone. I'll see you tomorrow, 8:30 G45.
Can I really quick, may I say something?
No, you cannot. We're done. We're off the record. It's 5:37.
I gotta get all my.
Okay, I have to write down. Do you have
I have to get my shit.
I just thought of that when
John?
that's all about the door.
John, can I speak to you really quick?
Okay, they're waiting. Okay.
I fired you. Can you come over here?
I guess the question is, does it make a difference between now and 8:30, right? Well, he said he works tomorrow.
Oh, is that, yeah, that's right.
Maybe, I was like, are they back?
Oh, yeah, could you try to catch him? I'm gonna go type that letter right now.
Or maybe they're still in the jury room?
Yeah, kid kind
So
of
I'm not gonna have to
Hale's
judge
kind of
how
looks
you
like
move out. I'm in GP, I'm not in punishment. I've never done anything wrong in the jail.
What's that happen today?
So I'm not gonna have to judge how you move out of the hole. I'm in GP, I'm not in punishment. I've never done anything wrong in the jail.
I've never done anything wrong in jail. I find that hard to believe. So it's
What's that
gonna
happen today?
so that was Friday evening. Now it's gonna be Saturday morning. We'll probably try to get through the rest of his testimony. And then tomorrow I think we'll do closing and verdict. And if he is convicted, I don't know if he will be. If he's convicted, we may do sentencing. But that's only if he's convicted, though. So I don't know yet. I haven't looked. He may get off.
We're just rolling. I'm recording it. Gentlemen.
Well,
Oh, yes, I'm already we gotta go 10 comes tonight.
And the judge had to get special permission from the chief judge to come in on Saturday, and they had to use a different courtroom, and they could only go from like 8:30 a.m. to 12. So they had to like change everything. It was a whole issue.
Those are the rules. Is that clear, Mr. Olson? Ruling before you. I'm going to try to be helpful today in reminding you that the rules relative to your testimony, which is allowed in the narrative form, is first and foremost to keep it relevant. And that secondly, if there's an objection, whether by you or by opposing party, that you are to wait for my ruling before you speak. There may be occasions when it's not necessary for me to entertain short, succinct arguments of the parties, and I'll just immediately rule. Other times I may inquire, but you are to wait for the court's direction on that. Additionally, there is no arguing and there is no commentary allowed, even when you're testifying in a narrative form. For example, as I stated yesterday, the jury does not need to hear your thought process about what you're going to say and why you're saying it.
How much time has he spent in jail awaiting trial? This one happened in 2022, either 3 or 4 years. And he's also being investigated in Racine, I believe, for drugging women on dates and robbing them. So it's kind of his MO. That's why he's like called the Ripoff Romeo. And they haven't indicted him yet, but I imagine they will once this case resolves. So like he's even if he gets off here, he's got to, well, I don't know, if he drugs someone with the intent to rob them and they die accidentally, Suppose that'd be second degree. I mean, either way, he's going to jail for the rest of his life.
If you have something to say relative to your testimony, just make that statement. Those are the rules. Is that clear, Mr. Olson?
Yes, and can I say something, please?
Okay.
So the defense is not rested yet, and considering calling a couple of witnesses, if that's okay. I would definitely like to recall Detective Zawinski, and I would also like to be able to call DA Sadowski to the stand since she had off-the-record communications with my private investigator, a past relationship with DA Sadowski, and communications off the record with other court personnel, deputies by DA Sadowski about my case.
Okay, so,
And also, sorry, one more thing, I didn't interrupt you. I do have another motion for dismissal and mistrial with numerous issues that I didn't raise yesterday. Some are based on some of the issues yesterday, but I'm also asking that this motion not only be submitted into the record and heard before trial is over, that they also be forwarded to Chief Judge Carl Ashley, the Kent Laverne, Sheriff Dean DeBall, the FBI.
okay, I'm going to stop you there because we don't have a whole lot of time today. I've only been authorized to have this room until noon. So I'm not going to pretend like you are the judge and you can take direction of how this case proceeds. I'm going to say that once and I'm going to make it very clear. Okay. So yesterday, there's a process and procedure to everything. Yesterday, okay, after state's case in chief, pursuant to procedure, I entertain motions. The court made a decision. We move on. You'll have another opportunity to motion the court, but we're not there yet. Okay, so do not go on the record with those motions because now is not the time. All right, let's bring in the jury. I understand that given what you just indicated to me, Mr. Olson, you do have one witness in addition to yourself, and that being the detective. So after your testimony, I'll allow you to call that witness, and we'll proceed relative to your request to also call the prosecuting attorney in this case. What case law or legal authority do you have to say that you can do that in this very trial?
So
Until you can provide that legal authority that allows you to do that, the answer is no, you're not allowed to call the prosecuting attorney in this very trial. That is all. That is all. I've addressed the witness lineup relative to timing, and now we're going to go on the record. Let's bring in the jury. Put your hand down, Mr. Olson. We're done.
Yeah.
Oh, I'm sorry. We should have had Mr. Olson set up first. I'll take attendance, have him walk back a little bit for a little bit, and then actually, now I'm serving the room. There's no witness box. Oh, so this time. And exhibits show that. Yeah, that's correct. That's consistent with yesterday. Just paper exhibits. Okay, we're ready. Right, are you ready? We're on the record in the presence of the jury. Good morning, members of the jury. Again, I want to thank you for your patience. I thank you for reporting for service today. We're in a entirely new courtroom, and so if you could just give me your jury number, and I'm going to take your attendance on this new seating chart, starting with the first row on my right.
Your attendance? Good Lord, this is a school.
When you return from break to sit in the same seat. And now that I have attendance, I know where all of you are located. Also, just be a little patient with the parties as we go through this process because this is a new courtroom and it may take a little bit of time for everyone to get used to where things are. As you may recall yesterday, Mr. Olson was in the witness stand
Judge Mark A. Sanders is hot.
testifying, and that's what we will pick up. Mr. Olson, at this time, I have you sworn in, and then you can commence your testimony.
Do you solemnly swear to tell the truth, the whole truth, and nothing but the truth, so help you God? Thanks, sir. It is for the record, could you spell your first and last name?
Mark has a nice body.
Okay, and that exhibit number is?
In a row.
Mr. Olson, make sure you speak into the microphone.
No.
Okay, sure.
Oh, it is. All right. So I don't remember what time it was, but apparently it was around midnight that she created this account and phone number for us to communicate with. And then somewhere after that, I thought it was probably maybe
Real men wear pink.
after 2 a.m. I'm not positive, though. It could have been right around this time that it states here that the UTC time of 6:49, which would translate into somewhere after midnight. But I think it was quite later than that. He did text me through this Google Voice number, and asked me where I was at and if I was coming back. She also stated that wanted to make sure that I never. She said, "You didn't tell Rex that you knew each other, did you?" There was another text indicating that her credit card had a $25,000 limit, which I would not have known without her telling me. When I got back to the car, when she texted, I wasn't even aware that she texted. She showed me the text on her phone saying that she had texted me, wondering if I had got them through the Google Voice. So this is why I know the texts were in her phone.
Hey, Randy. Yeah.
Also, she informed me that the next day she had to meet her brother for Thanksgiving at Mayor's.
Sustained. Next question. I'm sorry. Continue your testimony, please.
Okay. So we were going to meet back up after her meeting with her brother at Mater's. I forget what time that would have been. She was going to go early as possible and then come back to meet me, and we were going to go out of town. I didn't necessarily know where, but just somewhere like northern Wisconsin, maybe.
Yeah, just, the random 79-year-old woman you met recently, you're just gonna, what the hell? Let's just get out of town. Let's go to northern Wisconsin. Let's just hang out as friends. Maybe find Chandler Halderson's parents, parts of them.
As I said last night, we went yesterday. Sorry, we went to several locations. Sometimes we paid with her card. Sometimes I paid with cash. I did leave a couple of times from the car, venturing out. She just stayed there in the car. I don't know if she drove around at all, but especially when she texted me. Throughout the night, she also made me aware that she didn't want me to leave. She did inform me that she would have power of it.
Sustained.
Okay. I knew that she had power of attorney over her brothers of financial affairs, medical care. From that night and other. Your Honor, I object. It shows that I had.
The court has made a ruling. Continue.
So sometime early morning, we had an argument. Wasn't like no violent argument or anything like that. Just disagreed on things, and this did happen throughout the night.
Every couple needs to have an argument every now and
At
then.
some point was when I decided to just get out of the car, and she was going to go visit her. She was close to going to go visit her brother anyway around this time. She was going to drop me off somewhere else, but because of the argument, I just got out of the car and
how it
drove off down whatever road that was. It was on the map. So before that, let me think.
Don't hurt
So
yourself.
before that, we had planned, like I said, on her. She was just driving. It wasn't far from where I got out at, but it was just to the point where I just wanted to get out of the car. And we were supposed to meet up soon after that. She was going to Mater's to meet her brother,
Sustained.
and then she was going to come back to get me.
Okay. Sustained. That part of the testimony is stricken from the.
I object to that.
Okay. Members of the jury, we're going to take a break, and then we'll have you back when we're ready. Okay, I remind everyone this case is not concluded. You're not to talk about this case and you are not to conduct your testimony. Okay. And so you were argumentative. You want to have the last word, as you often try to do. Therefore, you violated the court's rules of decorum and the court's rules relative to your testimony. You have forfeited your right to testify. You may now be returned to your chair, and you're going to be allowed to call your next witness. Okay. Let's get off the record while the deputies do that. All right, thank you.
I would also like to place,
Mr. Olson,
can I place something on the record?
another violation of the court's rules of decorum. Okay, we're going to go off the record, and you're going to be returned to your seat, at which time we'll come back on the record.
I love how the prosecutor was like, yeah, I don't even want to cross him, but let's not strike that from the record, though.
The court's rules of decorum.
No cross.
Well, I'd like to object to not being to testify about the other allegations. I was just objecting to your ruling. I wasn't going to argue it, just show my objection on the record. I was not trying to break any rules of decorum or anything. I just wanted to make my objection known. But I mean, I clearly am objecting to my right to testify on my own behalf. The jury does not even know my side of the story for these other allegations. And I would definitely declare this a mistrial and for the clear prejudicial and biased narrative you're displaying towards me constantly through the media in front of everyone. This is clearly prejudicial and judicial misconduct beyond. It's bizarre. It's not even grossly shocking and shocks the conscience. It's beyond that. It's bizarre. You're clearly siding with the DA and you're allowing her to say whatever she wants, and I don't get to say anything. So, I mean, I guess we'll just continue with this legal lynching.
We will continue. Not everything deserves a response, so I'm not going to respond to that. The record is quite clear as to what transpired. We're going to bring in the jury. After they're seated, then you will call your next witness.
And my motion?
Yeah, we're ready.
No.
So he's calling the...
We'll discuss this more in the record during a break. I'll allow it. You may answer the question if you know it.
No. Through the investigation, was there any proof video of Mr. Olsen physically forcibly restraining anyone, not only Betty, but anyone in throughout this investigation?
But with the caution that, okay, actually, it's just going to be better back. Okay, members of the jury, this case that concluded, did not talk about it, did not. The jury, Mr. Olson, the state is correct that was a leading question, but to the extent that the court can appreciate that you are pro se and you're not a trained lawyer, nonetheless, you're still expected to know the rules. Yeah, I think that's helpful in just us moving along. As you may recall, and I said it before, that it's not an exhaustive list of things that you can and cannot do during examination. And you are on direct of this witness because you are calling him. That on direct, you cannot ask leading questions. And I want to make sure that you understand that. It's been said so many times, but for purposes of ensuring that you have a fair opportunity, I'm reminding you yet again of the rules. And again, you are expected to know the rules. Is there anything about what I just said and how I explained things that do not make sense to you relative to your direct examination of this witness? So, in my defense, Attorney Wazowski just informed me of the difference between questioning him as cross-examining or as a direct witness. So I will do my best to make sure that I form the questions in the manner that they're supposed to be formed. And if they're not formed in that way and accidentally formed another way, the DA is more than welcome to object, but I will try and keep them that way. I would not do that purposely. Well, and which is why we are having this discussion on the record outside the presence of the jury, okay? Rather than admonish you during the course of your examination, I wanted to redirect your focus to what's permissible and what's not permissible. Also, there, besides the fact that on direct you cannot ask leading questions, had this witness been called adversely and noted as so on the record, things could be a little bit different as well. I recognize that there are some things here that could, within the court's discretion, that the court can allow, and that's why I want to have both parties aware of where I'm coming from relative to all of this. Okay, but going forward, do you understand the boundaries by which you're supposed to operate, Mr. Olson?
Yes, but
Okay, that's all. I just need a yes or no.
I mean, I don't have a lot of experience with.
Okay, we don't need to rehash history here. Okay, let's bring in the jury. We're ready. We are still on the record, but no one is allowed to say anything on the record at this time.
Like when I'm asking about the video, or if he has any proof.
Oh yeah, I need water too. Mr. Olson?
So, according to Judicial Code of Conduct 60.04, you are to allow me to speak since I have legal interest, especially since I'm self-representing, and you're also not to show prejudice or bias in front of the media or any co-personnel in the courtroom.
Mr. Olson, if that relates to your request that the court declare a mistrial, I've already explained there's going to be a point in time for you to do that. Okay, now is not the time. So, Mr. Olson, please continue your direct examination.
So, Detective Zalewski, during your course of this investigation, did you or did you not find any video evidence or any other proof of Mr. Olson ever having a gun? No. Detective Zalewski, through your investigations of this case, did you or did you ever not find any evidence, proof, video of Mr. Olson physically restraining anyone, including Betty Hannell?
Proof of you restraining anybody? No.
Through investigations, did anyone ever witness Mr. Olson actually taking anything from anyone? Did you or did you not?
Objection, confusing. Sustained. Re-ask that question. Do you have any more questions, Mr. Olson?
Yes, Detective Zalewski, through your investigation, did you or did you not find any proof of Mr. Olson forcing Betty Hannell to do anything? No. Detective Zalewski, through your investigation, did you find any proof of, did you or did you not find any proof of Mr. Olson forcing Betty Hannell to drink anything?
Yes, through Betty Hannell's statement.
Did you find any video evidence? Did you or did you not find any video evidence of Mr. Olson forcing Betty Hannell to drink anything?
No.
Did you or did you not find any? Did you or did you not find any controlled substances in any of these bottles that you tested? No.
No.
Through your investigation, Detective Zalewski, did you or did you not find any video evidence that would prove that Ms. Hannell and Mr. Olson were not actually together?
Objection, compound question. Sustained. Ask your next question.
So, Detective Zalewski, how many investigations have you done into kidnappings?
I don't know the number off my top of my head. I have investigated kidnappings before. It's not a common investigation.
Oh, Lord. Hi.
You decided to turn up here on stream.
I've been here the entire time and I go get a drink and
You were gone for like freaking 20 minutes.
I was gone for like 3.
I've been watching.
Have you?
You ditched.
I pulled a Ricada.
I don't want to know about you pulling a goddamn Ricada.
I meant disappearing for an hour.
You got people here.
I was barely
You have
gone.
company? Dear me. Luckily I showed up. I was going to take over.
Oh,
I was just
here.
about to take over the ship.
I'm here right now. Relax.
Oh, now you're here.
Relax.
Dear me.
Calm down. Calm down. So have you been watching?
No.
Oh, that's too bad. Well, you just called the lead detective up.
Well, I noticed he looks like a cartoon character, like literally like a cartoon character. What the fuck is with this dude?
The detective?
Seriously? Yes.
He looks very... He looks kind of like a Dr. Seuss character.
Yes. Franklin Police Department. Like, honestly, how does he go to work like that? Does he go actually and knock on people's doors and tell them that their loved ones are dead looking like that?
No, he's not a homicide detective. He's not important enough.
Oh, okay. So he deals with things like, elderly being abducted.
Yeah.
Right. So he goes to like the children of elderly and says, oh, well, by the way, your grandma or your mom got abducted. He goes and
It's
tells them
10
stuff
p.m.
like that.
You know where your grandma is at?
And he does that like this.
Well, sometimes he wears a pink bow tie and it like spins.
Holy fuck. Seriously? Really? Quit
I'm sorry, did you say
judging.
you have investigated?
Yes, I have.
There's a level of professionalism, surely, that you would need to have. Like, are you allowed to like turn up with like a mohawk, for
No.
example, and go to
That's why
people's
he had to
houses
shave
and
his
tell
head.
them serious things like that? I love plaid. He just looks silly. Sorry.
I mean, he looks like a... I'm sure he's nice.
Sure, he's lovely. Man, Chad is rough on the bow tie detective. This isn't even the worst thing he's worn. Like, yeah, the other day with this suit and a pink bow tie,
Oh, yeah.
like he literally looked like he was selling candy in a Willy Wonka factory.
We all need a backup plan.
Sean's here. Hi, man.
No number off the top of your head?
I don't know the number off the top of my head. It's not a lot.
Less than 5?
It might be around 5.
Okay, out of those investigations, how many times did you not use the interrogation of a defendant?
Objection, relevance. Sustain.
Okay, of those 5 or less alleged kidnappings that you've investigated, how many did you not completely investigate video evidence of?
Objection, relevance. Sustain.
May I object? And I just wanted to object and maybe rephrase the question so that it can be asked properly.
Yes, you may rephrase the question.
Nick object.
All right, members of the jury, I'm going to release you for a break. Plan for about 5 minutes, and when we're ready, we'll bring you back. I remind everyone this case is not concluded. Okay, we're outside the presence of the jury. Mr. Olson,
Yes.
in between questions, not every question, but in between most of your questioning, you're taking up time and you're waiting about a minute, sometimes a little less than a minute, but the last one, you waited a minute before you move on. So we're going to go off the record. I'm going to give you a little time, not a whole lot of time, to collect your thoughts and do what you will in the organization of your questioning of this witness. But what I'm not going to allow you to do is to use time in this manner.
Okay.
It's permissible for you to think on your feet, but you taking about a minute in between most questions that you ask it's just not going to be conducive, okay, to me moving this case along.
Okay, Ryan, I have a quick question. So I clearly think that the manner in which this was investigated is relevant because it shows that the detective knew that there wasn't really a crime happening, because a serious allegation such as kidnapping, they would want to investigate any possible video, especially to see if someone was physically harmed.
Mr. Olson, how this detective investigates other cases has no relevance to this case. Maybe he did a great job on the other cases, maybe he didn't. But what does that matter in this case? It's about what he does or what he did in this case that makes it relevant. Does that make sense?
Sure, but
Beyond explaining it that way, I don't want to cross any lines and to make it appear that the court is advising you of how to formulate your questions. But in the interest of time and by way of example, I've explained it that way. And that's the best I can do. I'm going to go off the record so that you can have that time planned for 5 minutes. You should have had this done already. Okay, we're off the record. Now it's time
She's
for
mean.
and Senior Princess before with State and Mr. Olson and standby counsel. Okay, so Mr. Olson, your time would have ended at 9:47, but you had a little extra time, so we're going to now bring in the jury. We're ready. Okay, welcome back, members of the jury. Mr. Olson, please continue.
Detective Zelensky, through investigations, did you or did you not find any video evidence of Mr. Olson actually committing a crime?
Objection. Relevance.
See, he's ignoring me.
Well, I don't know that that would be the right basis for the objection. Response?
You're ignoring me.
I
tend to. Why?
You do tend to. You've been ignoring me for the last 5 minutes.
I know. It's longer than that, I assure you.
Oh yeah, the last 2 years. Oh,
Sorry, I was setting up the stream for tomorrow.
yeah, right. So this judge, I can tell, like, she's clearly got the shits from the last few days, but for this pro se defendant to be taking some time between questions, I don't think that's actually that big of a deal, right? Like, he's done some shitty things over the last few days, but he's trying to work out what his questions are between, like, in between.
Yeah.
Like, he's on cross, right? Oh no,
direct.
he's
Well,
calling,
he
not direct.
recalled the directive on his case, or recalled the detective on his case in chief.
Okay, he ain't a lawyer.
No, but he's also trying to delay things.
But that's subjective.
Wow.
This is a court. Yeah. Hell, stop interrupting Darlie during emotional moments. I mean, I'm pretty sure I interrupted him on the potty earlier, like when I came in. But I'm just putting it out there as a matter of his due process rights.
Sure.
He is a pro se defendant. He's not a lawyer. All he's doing is taking his time to formulate his question. And I think she's got the shits with him.
Yeah.
And so what? He's taking a bit of extra time to sort out his question rather than just like coming up with a bunch of bullshit.
I mean,
am I wrong?
No.
Stop being so reasonable, hello.
The judge has to be
You
done
hate
by
him.
noon. So, and the
Oh, she
trial's
has
already
to be done by noon.
Yeah, they have to be out of there because it's Saturday, last Saturday, and
Oh.
you have to get out by noon, and they've already like 2 or 3 days longer than it was supposed to go. So yeah, he's trying to do anything to create a mistrial, and
But that is also speculation. Like, you can't, like, that is, you, to say he's trying to create a mistrial and he's trying to make it go for longer, that can't go on.
Yeah.
That's not on the record.
well, his actions are, or what he said and done is.
Yes, but
And
that's creating an
judge
inference.
make a finding.
Yeah.
That's what he's doing.
Yeah. I mean, he's no Darryl Brooks and he's not as annoying as Laurie Vallow. So,
Sure.
I mean, Laurie Vallow, as disgusting, and I mean disgusting as she is, I didn't think she did that bad of a job of
No.
representing herself.
I
and
mean,
she
that was
was
kind of
pretty
more on, I think,
organized.
Trina, the
Sorry.
prosecutor, kind of. I don't want to say she blew it, but I think she was unprepared for Lori to actually be prepared,
Yes.
and that threw her off. So
Yes.
she really struggled in the beginning, and Lori came out pretty strong.
Lori came out far stronger than she thought.
Yeah.
Yeah, exactly. I think she expected her to be just a complete mess,
Like this.
and she wasn't.
I think we
like
all did,
this.
actually.
Yeah, everybody thought she was going to be.
She was going to turn into a joke. And no, it was. No, I mean, there was. She had, like, on the first vote, 2 or 3 of the jurors were not guilty.
Really? I don't remember that.
Yeah.
Wow.
At least one was not guilty, firmly.
Yeah. And the judge was, he did. Laurie wasn't expecting the judge to shut her
That
down so
too.
well, and he did.
Yeah. Yeah, I liked him.
It was pretty good. All right,
Yeah,
sorry.
he didn't get angry, but
Yeah.
just stern. So yeah, we'll go a little bit longer.
You might disagree. She was messy, yes,
Oh, yeah.
but nowhere near as much as we were expecting.
Yeah.
I guess, Randy. Yeah, like we were expecting her to just be all
Disaster.
over the place, a disaster. But
And,
she
yeah,
was far better than I was. She was better than I was expecting.
I'm comparing her to other pro ses, not actual lawyers.
Not lawyers. No.
As far as pro ses go, she was up there as more competent than not.
Yeah, better organized, more able to represent herself than other ones we've seen. I mean, like her, Daryl Brooks, her.
Yeah.
Yeah. Okay, come on.
Okay, well, you're asking for a legal conclusion, which the witness is in a position to make, so the objection is sustained on that reason. Next question, please. Ask your next question.
I love his goofy smile. So annoyed.
Mr. Olson, ask your next question.
Oh my God. During the investigation, Detective Zalewski, did you or did you not find any video evidence of Mr. Olsen actually committing? Did you ever find any video evidence of, or did you not find any video evidence of the burglaries that were alleged?
Can you repeat the question?
During your investigations, did you or did you not find any video evidence of Mr. Olsen being involved in a burglary of the RV that is alleged to have happened?
No, I did not find any video evidence.
During your investigation of the burglary of the alleged burglary of the garage, did you find any video evidence of Mr. Olsen being involved?
No.
Ask your next question.
Oh my God. That's all I need for Detective Miller.
Class? Detective, do you have to be physically touched to be restrained?
No.
No. Could you go over a couple other ways that someone might be restrained without being physically touched?
Oh. Through pauses.
It could be the passenger in the vehicle unable to leave.
Sorry, did you say we're skipping through pauses?
Good, thank you. Perhaps
Yeah.
We are.
someone alleged to have a firearm, would that restrain another person?
Yes.
Well, there wasn't video evidence of the burglaries. Were there other types of evidence that you were able to locate in this investigation?
Yes.
Could you tell us about some of the evidence regarding the garage burglary?
In your testimony, the garage burglary, there was a red bike in the garage. That's the same red bike that Mr. Olsen had in his custody when he was observed by Officer Frusti at 35th and Lawson, where he then fled and dropped the bike, where it was later recovered.
And then regarding
Objection,
evidence,
Your Honor.
objection to question, or
Sean, for this.
To his response that
you don't get to argue with the witness. You can object to the question. Let's move on.
Much appreciated.
And then regarding evidence of the RV burglary, was there any evidence located regarding that an recreational vehicle was burglarized?
yes,
Yes. And was that evidence the items that were found on Mr. Olson when he was arrested?
yes.
I have no further questions.
Redirect, or in other words, follow up to that.
Nothing further for the detective, Your Honor.
All right, thank you, Detective. You may step down.
Thank you.
Defense, please call your next witness.
I would like to call D. Sarah Sadowski as a witness, Your Honor.
Not allowed. Anyone else? Does defense rest?
Just a second, Your Honor.
Can I call you? Can I call the judge?
So subject to filing of my motion, I didn't want to rest until that was placed on the record, Your Honor.
I've already explained procedure relative to when I'll take that motion. Does defense have any other witnesses to call?
No.
Okay, so
Gosh, Patel.
for the time being, defense rests, subject to rebuttal, is that correct?
Yes.
All right, thank you. Does state have any rebuttal witnesses? No. Okay. So members of jury, I'm going to release you for a extended break, planned for about 30 minutes. There's some things I need to take care of, and then we'll bring you back when we're ready. Okay, I remind everyone this case is not concluded. Do not talk about the case and do not conduct your own research, not post about it. Okay, thank you. Outside the presence of the jury at this time, now that we have reached a point in the process where both parties have rested, Mr. Olson, motions, if any.
Yes, I have it's a motion to dismiss based on many issues and for a mistrial and requesting an investigation into the phone download specifically and prior to the end of trial.
There, and I'm
Right.
gonna try to direct you a little more than give you free range, because I allow you to do that yesterday. You wasted a lot of time. You have two motions before me. One is for dismissal, and this dismissal I imagine is related to the close of all evidence. And so what's your basis for the dismissal, your motion for dismissal? And I'll remind you that at this point, it's sufficiency of the evidence. What's your basis for your motion for dismissal at the close of all evidence?
So besides this one,
Okay, let me break this down. The way I understood what you just said is that you have two motions, one for dismissal and one for mistrial, correct?
yes, they're together. They're together in one motion.
I'm telling you to separate them, okay? So there are two motions. There are two asks of the court. One, you're asking me to dismiss the case, and two, or in the alternate, you're asking me to declare a mistrial, correct? Those are the two things you're asking.
Yes.
Okay. Now, as to your ask that I dismiss this case, what is the basis for that? And I remind you that it's sufficiency of the evidence. So let's hear it. What's your basis?
Okay, so the I'm entitled for count 4 again. I'm entitled to face the injured party, and I've looked this up. And caretaker, she claimed to be caretaker of her brother. That does not constitute ownership of the property. The injured party claiming damages or injury has to be present. That I have a right to face my accused under the 6th Amendment of the Constitution, and that person was not available in trial, was not ever able to be questioned. And again, I did ask his sister if she was ever owner of that property during that time. She's not power of attorney, anything like that. She was only taking care of her brother. That does not constitute ownership of a dwelling, and therefore those charges must be dismissed. I'm also, there's numerous, I wrote everything in the motion so it wouldn't take up the court's time in this manner, but there are numerous issues here that are extremely important that I think that the court needs to look at. I believe that there should be a completely separate hearing on the complete Brady violation, as when I did get time.
And I'm going to redirect you. Sufficiency of the evidence. Okay. Stick to that. Given all the evidence that's come in, because both parties have rested, how is the evidence insufficient to sustain these charges so that the jury may deliberate?
So
You've explained count 4. What about count 1?
Count 1, there's no proof of any kidnapping.
Okay, and then count 2.
Okay, also on count 1, there's no proof that that me and Betty Howell were not together, that we did not know each other.
Count 2.
Count 2, there's no proof of intent of using someone's card without their consent. In fact, it's just the opposite. We were together the whole time.
3, obstructing an officer.
There's definitely no proof of obstruction of an officer.
And then you spoke up about count 4 already.
Yeah.
What about count 5?
So in count 3, I want to add that I was actually tased while going to the ground, and this would have been shown in the video. I've never been
No commentaries.
Okay. Go ahead.
5.
I am going
And
to
count 5
count
is
them.
there's no proof that I did not know the defendant, and unfortunately was not able to testify to the fact that I stayed in that RV for quite some time.
All right. Now, give the state a chance to respond, and also if the state has their own motion. State?
She's pissing me off more than
Thank
him.
you, Your Honor. I think that there was sufficient evidence to allow all charges to go through. Betty's testimony
Why
alone
Christmas
covers
things
counts
still
1 and 2. The officers
What?
Look, there's Christmas decorations still up.
It's Mardi Gras.
Oh. Looks like Christmas to me.
I know. I
We'll
thought
just
so
go
too.
get
at
the
first.
Christmas decorations out. That'll
Yeah.
do. Yeah. Okay.
So we'll go for a couple more minutes, and then I'll redirect everyone over to Hellas Stream in 15.
Okay. Sorry. No, I thought I saw something, and then I didn't. I thought it was a dildo. Never mind.
Oh,
counts 3. Counts 4, possession of property under 971.33. What's sufficient? It's that sufficient that if the time the crime was committed, either actual or constructive possession of the general or property of any part of such property was in the person to be alleged the owner of. We had Christine Endell testify to the fact that although not the owner, she was aware that no one was going to take the property, did not have permission to take the property, and that she was watching the property while her brother was incapacitated. And that is also constructive possession of the property. So I think we have that covered as well. And regarding count 5, I think that there was also sufficient testimony that Mr. Olson didn't have the right to take or remove or be in any of the garage. Or I'm sorry, count 4 was the RV, right?
That's correct. The
Yes.
motorhome trailer.
Count 4 was the trailer. So please.
No, count 4 is the building.
Okay.
And then count 5 is the motorhome, the RV.
Count 5 is the motorhome. He didn't have any right to be inside of the motorhome or take the property out of the motorhome.
All right. Again,
Yeah.
as I indicated at this stage, with respect to motion for dismissal, it is sufficiency or insufficiency of the evidence. I haven't heard the arguments of the parties. I'll start first with count 4 because that's where Mr. Olson started. But I agree with the state that given the evidence thus far, at a minimum, it is sufficient relative to the legal definition of ownership or possession. Thus, that count, there is sufficient evidence to move it forward. With respect to the other cases, Mr. Olson may disagree with the evidence. He may disagree with what the witnesses said, but that doesn't mean that evidence doesn't exist sufficient enough to submit the case to the jury. For all those reasons, motion by defense for dismissal is denied. Mr. Olson, now I'm going to direct you to your other motion, which is a motion for mistrial. Please place on the record your basis for mistrial. And I'm going to give you 5 minutes for that. Starting right now, it's 10:06. It is your motion, so I'll let you.
Real quick, Snivels, thank you so much. Wow, 20 Dolly Talk memberships. That was very generous of you. Thank you. And everyone, please thank Snivels too if you got one.
No. You are amazing, Snivels. We love you.
Yes.
Love you.
You have the last word, but 5 minutes for you to put on the record your basis for that motion.
Okay. I believe the entire case should be declared mistrial because of the Brady violations. The 3 flash drives that I was given, or my attorney was given, I was given one by Attorney Bastian, 2023, and 2 here, and Attorney Wazowski can testify that none of those would function.
Mr. Olson, I'm going to interrupt you here for a minute, but you yesterday or the day before, I mean, this week is becoming a blur because of this whole entire circus. You already brought up your motion, and I entertain your motion for mistrial. Given everything that's transpired since then, is there new information to add to what you already made me aware of that I relied on in making my decision, which was a denial of your motion for mistrial?
Yes, I found on those drives since then that they won't open up because there's like some settings that were set on there for permissions, which clearly indicate malicious intent by someone, whoever made those files, and I could not open them up. Therefore, I have now, with the help of Law Library, enclosed them in an envelope so that they can be analyzed by DRP security services, who will analyze them to see how and when they were set up to the fact that I couldn't view them and that there were things removed and blocked, and so there will be time stamps to prove that this was done prior to being given to me and therefore violated my right and is a complete Brady violation.
But I thought that
Complete
in court,
Brady
in
violation.
my presence,
What is the little one?
Attorney Wazowski gave you his copy of the disc.
No.
Hi, Billy.
So what you had was Attorney Wazowski's copy, which in court, in my presence, the state opened and was able to open the Cellbrite download on her laptop. And again, it's a laptop, not a desktop.
Okay, so Attorney Wazowski just gave me his copy on the 4th day of trial, and when I took that back, it would not open there. So this is the problem with permissions, and I'm just recently finding this out from people who are experts in this type of thing, that it can be set so that it will only open up on certain laptops, not everyone's. So only certain users can open it. So when she opened it up on her laptop, not his, it's because there's permissions set for her to open it, not anyone else. She never opened up any one of ours. And the 2 that I've been given, the two that we were given before trial wouldn't function, and Attorney Wazowski testified to that. And that is what is important, that I did not have discovery before trial. That is a clear Brady violation and should be automatic grounds for dismissal of all charges.
Your next basis for mistrial.
And I was not allowed to access case law to provide my motion yesterday. I was only allowed access to my flash drives, not the law library, which has been taken away from me from the tablet that I normally have in the jail.
I believe I heard that already. Continue.
Okay, all right. So I need to re-add that 8 of the 12 jurors have talked about my case in the library. Near the elevator and as well as all through the hallways. And I've continued to be brought through the front of the courthouse instead of back routes, which normally are taken any other time I've gone to court except trial. DA Sadowski is also communicating.
Moment. Okay, continue.
So DA Sadowski is also discussing the case on her phone with friends, family, etc. in the middle of trial. From what I am also, let's see, and because of this jury misconduct, they are now all aware that I have requested mistrial for jury misconduct, because this has been all over the news, and this has definitely prejudiced the jury against me. It's a poison jury. I can never come back from that.
Okay, time's up.
You can let me finish, though.
I told you how much time you
You
have.
interrupted me. There's one here for judicial bribery.
I'm going to remove you from the courtroom for 15 minutes.
There's
Is that
judicial bribery here going on.
One more warning,
Judicial
and then you will
bribery?
be removed. Because that, I haven't even kept count.
You didn't let me finish my motion.
I cannot tolerate your disruptive behavior anymore.
No.
I've made this sufficiently clear before we started and shortly after we started. Okay. Now, I give you the time.
Let
Now
me finish.
Okay. Let's remove Mr. Olson, and we're going to
DA
continue.
Sadowski is bribing the judge, and
Okay, Mr. Olson.
this needs to be investigated by the FBI.
1-800-CASH. Cash.
Okay, so I have thoughts on this, and that little bust there is not happy. Is that Abraham Lincoln?
Yeah.
Right,
Wait,
Abraham
is that
Lincoln. has
Lincoln?
to
That's
go.
kind of ironic, considering he's suspended habeas corpus. I'm just
I
saying.
don't think Judge is handling this well at all.
No. Well,
She's
oh, you
rude.
weren't here earlier. She said she kicked him out and said he was going to be watch the rest of the trial by Zoom. And she comes back 15 minutes later when he's still in the back and says, well, so they took our laptops and there was an issue with them connecting to the internet. So technically we can't actually have him access the trial by Zoom. So then she had to bring him back in and make him promise to like behave.
Fuck's sake. She is really letting her temper get the better of her, and she is actually violating his rights. And I know that sounds stupid because he's being an idiot,
Yeah.
but he has rights. She keeps interrupting him. She keeps stopping him from making his records, and that's not okay. She can't do that just because she is annoyed. Last week, Randy.
Yeah.
Yeah,
was
this was last
Saturday.
week. Not positive that's Lincoln. I don't know. I'm an Australian. It just looks like Lincoln to me.
All busts look like Lincoln.
She didn't make him pinky promise. All right, I got to run.
Yeah, I'm going to end now too.
I'll see you soon, guys. I got breaking news.
Should be fun.
Bye.
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 Okay, so that was quite fun. We'll finish up tomorrow at same time, 5 Eastern. And we'll go over closing and verdict and see where we go from there. Thank you everyone for being here. Thank you so much, Nivels, Sean, JP Cole for becoming a new member, and Erica for the gifted memberships. Yeah, this has been a lot of fun. Oh God, last week no one was paying attention to this trial. Oh yeah, I woke up Saturday morning, and being the normal person I am, I immediately started just going on YouTube, and this popped up and said it was live, and I was like, why the hell is there court on Saturday? And it was this S show. So, all right, guys, I'm going to redirect over to Hella, and I will see you guys over there. Bye.